him.
Yes.
He's usually here right at the minute.
Good evening, everyone, and welcome to the Wednesday, March 25th, 2026 workshop of the Zoning Board of Appeals. Roll call, Georgia?
Here.
Drew?
Here.
Brad Fogg is here. Derek Shirley is on the way, to the best of our understanding. Our process tonight, our intent tonight is to do a workshop to review the zoning ordinances and our procedures that we use to help determine cases, the outcome of cases, and things like that. So I will lead this off, and Georgia and Andrew will tell me, well, where I'm going wrong and what we might do to do things better. So this little package I put together, we wanted people to know outright that zoning variances are really waivers of the zoning ordinance restrictions. In other words, the town of Gray has a set of zoning ordinances and what can happen in each one of those zones within the town, be it the village zone or the rural residential zone, you know, how people can use their land or how they can build on their land or how they can, what they need to do to be able to build on land and things like this. So if there's a problem or a person goes to the code enforcement office and asks for a building permit, and for some reason their building permit is denied, or they can't obtain a building permit because of dimensional requirements within the zone, they can appeal the decision of the code enforcement officer, and they can appeal the dimensional requirements or anything else within the ordinance that's preventing them from getting a permit or doing with their property what they'd like to do. The Zoning Board of Appeal in Gray is a quasi-judicial board. In other words, we are granted authority under the Maine state statutes, and our decisions, for the most part, are final unless the applicant or the appellant, the appealer, appellant wants to go to the Superior Court and seek to overturn our decisions. We're also governed by the Gray Town Ordinances, section 402.9.2, which is a rather long ordinance, but it encompasses the state statutes that we need. And then there's an ordinance for shoreland, specifically for shoreland in the town of Gray, and that's section 16 within the zoning ordinances. Now again, just briefly in summary, looking down through these things, one of the things that as a quasi-judicial authority that applied to us is, number one, we don't legislate. We interpret and we apply the ordinance the way it's written. And some of the things that we shouldn't be doing is that we shouldn't be talking about the application outside of the formal meetings. And we shouldn't be sending emails back and forth, because the emails that we have are public records.
Mm-hmm.
And that's why we have a graymaine.org email address. So any business that we conduct with regards to the zoning board, we should be doing it on the town's email system. We obviously try to be as impartial as possible, concentrating only on whether the application meets the written standards of the ordinance. We discuss waivers and we only discuss waivers that we have the authority to discuss, simply put. Consistency and interpretation is important. But if we discover that past practice has been wrong, we do have the authority to say, that's been wrong all along. In some cases, the ordinance has been written incorrectly all along. We do have the authority to grant an appeal and recommend, as we've done the last couple of times, ordinance changes to the Ordinance Review Committee. And I understand they're taking you've had a busy schedule, haven't you guys? The Ordinance Review Committee.
I don't think we've met, since I started to.
Yeah, I thought there was a couple of ordinance
Yeah.
changes before the town council, but
Oh.
that's another authority that we do have. Now, we also, I'm not sure if Georgia was here, I'm doing a lot of talking, but
It's okay.
I'm not sure that Georgia was on the board, but a couple of years ago, we did grant a request for a variance through the appeal process that we determined should be listed as non-precedent setting because of the circumstances around that specific property. And we didn't want to set a precedent for all others to follow, and that's, oh, hey, you get it for them, you gotta do it for us, you gotta do it for them. So we determined that to be non-precedent setting. And the town's attorney helped us write that finding. And I forget what the circumstances were, but it was a very unusual circumstance. So instead of just changing, broadly, what somebody could, oh, well, you did it this or you did that, we had to use it as a non-precedent setting so that people couldn't think just because we did it for one, we could and would do it for everybody, based on those circumstances. We shouldn't be considering the popularity of the project, and I know that sometimes people say, oh, this is the popular thing to do, and this is the way the town is going, and the comprehensive plan is calling for this or calling for that. Just because it may be a popular idea doesn't mean that it's necessarily the best idea, and we need to be wary of making decisions because of the popularity that might surround it. We need, our duty is, we need to process the application, which is actually the code enforcement officer's office. Process the application as efficiently and as fairly as possible, sticking to the ordinance. And when we do have public comment, and this is probably an error that I've been making on a fairly regular basis, is allowing public comment that really is not relevant to what we're doing. And a lot of it is, they're nice people comments, they're the nicest people, they've been good neighbors. It's nice to know, but it's really not relevant to the decision that we're making. So I think, personally, I have to be more cognizant of that. I mean, it helps people feel good,
Yeah.
but it doesn't really,
No, we need
it
more
shouldn't,
of the, it's
they
going to
shouldn't think
affect
it's
it.
gonna impact our decision-making.
Yeah,
Now, we apply different legal standards depending on the issue. Some appeals invite a fresh look at the policy. And all zoning board of appeals cases are de novo. We look at decisions previously made and then we look at them from a de novo point of view, which means that we're looking at the situation from the beginning, from scratch, all the way up through to see what's actually happened. And we do that because there may be, the party may be appealing a code or a reasonable or some of the previous decisions that are on record. It gives us the opportunity to look at everything. And we had a case, I'm not sure of the road name. It's just the one before, there's 202 that turns into Gray Road in Wyndham, and then there's Pleasant View Road. It's the one that Dean Bennett lives on. It's got the rock, Pleasant something View, I think, and then there's the road just before that. Again, I forget the name, but the road before that, there was a piece of property that we had to look at, and we had to trace the applicant had to trace the history back on how the property was subdivided as many as 50 or 60 years previous to that, to bring forth, errors that had been made, which allowed us to, well, you're right, an error has been made, there needs to be some type of correction done at the Registry of Deeds, and we granted the appeal or the variance with the stipulation that they would present to the code enforcement officer the correction in the deed, so that that
You
could
tell
move
me about
forward. And it actually freed up the other 8 or 10 lots to become buildable lots. And it was just that one piece of property that was holding up. So that's an example of the de novo hearing that we had in the investigation that we had to conduct, and the material that the applicant had to provide, because they carry the burden of proof. We carry nothing. We say, oh, yeah, we're convinced or we're not convinced. And that's pretty simple. So you want to say something? Oh, okay. Now, we're looking at the second page. People apply for a hearing with us when their permits are denied, when enforcement action that the code enforcement officer might take stops work because something happened, or there was a refusal somewhere along the line before it got to us to grant an exception, or the town ordinances identify which decisions are appealable and the form in which they can do that. Be it a zoning board, an appeals to the planning board for a denial of something they did, or an appeal to us. And those are the two forms that are available to people in town. If they're planning the development and the planning board says no, or there's something about what they call standing exception 1 that the applicant can't comply with, and they can go back to the planning board and appeal that process and see if that decision can be changed. So we're at the point now that Brad Fogg has a piece of property, wants to build on it, or there's something else going on in Brad Fogg's life, or his family life, or his property's life. There are 5 different types of appeals that I might submit. And these are also further on in the package that we have. The first one, or one of the ones that they have is an application for an administrative appeal. And they simply submit a 1-page form, which is always the best as far as I'm concerned. What are the facts surrounding your appeal, and what do you think is wrong about it? It wouldn't be like Andrew going to the judge and saying, well, Judge, I didn't really speed, but, and they spell it out, and the code enforcement officer looks at it, they move it forward to us. We hear what they want to present, we hear their evidence, their testimony, their facts at a meeting, and then we come to a decision. It's probably one of the simple things that we could do, and I don't know that I've ever had one of these, to be
I was
honest
gonna
with you.
say, I don't recognize ever seeing one.
That was the kennel one, because
It was an administrative appeal,
I-
or was it a?
Yeah, I didn't think it was.
Or was it not a it was a, why do I have all these shoreline appeals?
I don't know, I got a lot of them too. They're all shoreline. Wait a minute.
Or was it a hardship appeal?
Yeah, I thought that was a hardship.
I think that was a hardship appeal. So
But she
let's,
filled out one of these forms.
why did you have all this? I did that wrong, didn't I?
Well, we got them, they're in the packet from Inga.
Okay, let's look at English packet. Which is this one?
It's practical difficulty. Maybe that's what it was. Hardship.
Where's they asking if what they were doing didn't actually constitute kenneling?
Well, ultimately, that was the
Yeah.
the interpretation that they wanted to kennel, because the kennel, the ordinance in the village zone, that was the village zone,
Right,
didn't allow for kenneling
for a fee.
for a fee. And Drew brought up some very interesting questions. Are they really kenneling? Not Drew, but Derek brought up some very interesting questions about kenneling. And is kenneling cats? Is kenneling dogs? You know, how much more traffic would be increased if the person was allowed to conduct the business, but the business was related to the number of animals, and then kenneling was more than two, I believe, in that
And-
case. But based on Drew's perspective of what the zoning board actually does, did the applicant successfully prove that the code enforcement officer had violated the ordinance as written by denying the appeal? And ultimately, the answer was the code enforcement acted and interpreted the ordinance correctly.
Right,
So there were no grounds for appeal,
no,
and we denied that. So, I mean, that's what happens. So there is the practical difficulty appeal, which is the dimensional standards. And that was the practical difficulty dimensional standards was the one we had last month of the person that wanted to build, when in fact, there was a dimensional restriction, and they needed 1 foot ultimately. After the application was amended, they only needed 1 foot.
right, from the overhang.
So that's a practical difficulty, dimensional. And the practical difficulty is probably,
We see those the most, don't we?
we see that the most, and they're probably one of the easiest ones that we do. I mean, because we look at the neighborhood, we look at the size of the lot, we look at, the dimensional standards. And, I mean, we answer these 5 questions, 1, 2, 3, 4, these 6 questions on the back of that form. But we also need to remember that when we are doing that, we have to look at the ordinance requirements, criteria below, to make sure that we're satisfied that we can give due consideration to each one of those and agree that there won't be any negative impacts to that. Another one we do is the hardship appeal, where if we were to relax, people are looking for a relaxation of the terms of the ordinance that hopefully would not be contrary to the public interest. And this looks at setback requirements, it also looks at, and this is the most difficult question that we have to answer, that the land in question cannot yield a return unless a variance is granted, a reasonable return unless a variance is granted. And to that, I thought I had included in that package, all the way at the end,
Andrew Hill's article.
yes, which describes the litmus test of whether the land can return, have a reasonable return. And the courts have consistently ruled it's not necessarily a monetary return on the value of the property. And in Raymond, there was a landmark case on a piece of property that the owner wanted to develop, and it didn't meet the dimensional standards. And the courts basically said, you can put a campfire and benches out there, and your property is yielding you a reasonable return, not necessarily monetary, but, you know, social, behavioral, or type of, and so the land has value. And at the last workshop that MMA conducted, they had beachfront property somewhere in York County that didn't meet setback, waterfront setback, but the people wanted to build like a little cabin or something, camp on it, and, well, you can't do that. So, well, you know, we'll never get our money back. Well, reasonable return in that case didn't mean, you know, money back, because did you have reasonable ongoing use of the property? And yes, you could sit there, you could do picnic, you could beach, you could swim, you could boat, you could, you know, do all these things. So this is the one, out of all the years I've been doing this now, this is the one requirement that really is the toughest one to look at an applicant and say, but, well, I've got this much invested in my property, I won't get a reasonable return on it. We understand that. However, are you getting a reasonable return or use of the property, not necessarily a resale of the property? And I think the only time that we may have granted one of these is when to make the property usable to any degree, be it to set a camper on or a campfire on. It was the guy that had to put so much money into building the berms to prevent the flooding.
That must have been
And
John's
it was a
time.
very odd shaped piece of property that we actually granted the appeal because we felt that, well, you really can't use the property no matter what unless these things are built or this improvement is allowed to be made. So we actually did at that one point in time. But I feel that's the most difficult criteria we have on the hardships. So again, I've created or reproduced the Andrew Hill hardship test explanation pamphlet for us to have and look it over. And you know, is the hardship pre-existing, or did the person create the hardship? You know, what happened? What happened? Unique circumstances, property, lakefront, oceanfront, you know, where is it located? Like the Camp versus Town of Shapley, the proper application of this problem will require something actually unique about the property. For example, a lot with an odd shape that other area lots do not have may be a good lot for a variance. So if it's, you know, shaped like a pentagon, and you couldn't build on it, and all the other lots are, and this is the creation of a lot as a result of other people doing the development, there may be cause to grant that variance because it was arrived at by no action of the owner of the lot itself. In other words, you know, the hardship was created by others, imposing on them or imposing developments that negatively impacted his reasonable return. Again, so I feel that's the most difficult criteria that we have to look at. All set?
Yeah.
Shoreland, let's take a look at shoreland. There are two different shoreland appeals. The first, again, is very complicated, or not very complicated, but according to the zoning, the shoreline zoning, structures cannot be built within so many feet of the shoreline, be it, riverfront, stream front, pond, lake. And people can request a variance. You were here, Drew, weren't you, when we did the one off Campbell Shore Roads?
No, I don't think so.
I think he was. That's the one where the guy agreed to change the position of the structures?
This is my third meeting, so I saw the kenneling and then I saw the practical difficulty variance last month.
Okay. There was a piece of property over off Campbell Shore Road where there was a swampy area that was dissected or bisected by a stream, and the land was bisected by the stream, and there was a road cut in there by the developer of the property, and plans are submitted to build structures on the right-hand side of the road, but some of the structure would be within so many feet of the stream running through the back, and how can they rearrange things and do this and do that? And because of footage, and the applicant agreed to move some of the structure.
They agreed to move part of the structure, and there was something in the way the property was cut
Or laid out.
that what they were saying as shoreline really wasn't shoreline.
Well, they were
Because
saying
it was,
that.
yeah, I mean, it was, they were saying that this wasn't really shoreline because it was a point instead of lineal.
Well, I think what they ended up doing was agreeing to move
Yeah.
one of the structures,
Mm-hmm.
and because they were making that compromise, we granted a variance, a dimensional variance within the shoreline. I think it was for 4 feet,
Yeah, it wasn't a lot.
4 feet over like a 25-foot section. You know, because they were looking for, like Georgia says, it was just like a little point around, like, and so we granted the variance because it was like, seemed practical to do that. And it allowed for the development of the property. And again, because of the way that the previous owners had sold and bisected the property, well, you took all this land and basically just made it useless.
Yeah.
Mm.
right.
And I don't think that anybody spoke out against that either, did they?
No.
So there was that one, and then there is the
Disability one.
disability one. And
I don't think I've had. one of
Tammy
those.
actually touched upon that a little bit on disability variances at our last meeting when the person needed a variance, was alleging the variance and disability so they could build the step inside the garage to go up into the
Right.
house. Disability variances in the shoreline can be granted with certain criteria, but the structure cannot be permanent. The board shall restrict dwelling accessibility to a person with a disability who resides in or regularly uses the dwelling. So a temporary, let's say, handicap ramp can be placed into the shoreline zone. And if the disability no longer exists, it's a tough way to say that, isn't it? Then the structure itself has to be removed. Now, there are some people that will say, well, we need to put it there because we kind of made it too good.
Sure.
Well, sorry.
Yeah.
And we had a case a couple of years ago, the McKinnon property down off of Brown Road, where the person wanted to enlarge their garage to be able to accommodate a handicap van. that the person was using to get, but they weren't a permanent resident of the house. They were a regular visitor to the dwelling. And I think the compromise was, you can build a covered area over your driveway, but we're not going to allow you to enlarge the garage and negatively impact the setbacks by several feet, when the person could use the ramp in the van to go into the garage and use the existing ramp into the house. So these are some of the things that we face. So we have the shoreland, we have two in the shoreland, we have the practical difficulty, we have the hardship, and the administrative appeals. And in all cases, the burden of proof is on the applicant. Now, what we look for, and what I would like to see more of, on page 3 of that thing that I did, we call it, there's evidence and testimony preparation. I would like to be able to offer a suggestion to the code enforcement office. And part of this comes as a result of last month's, well, we have to change the dimensional standards right in the middle of the thing, call for, make a motion for an amendment. When the error was made prior to the meeting, I'd actually like to see those applications more completely reviewed by the code enforcement office, whether it be Tammy or Inga or anybody else within the office. But I'd also like to see, because unless we plan for a site visit in advance, I think I'm gonna go off track. Whatever happened to that driveway over off Brown Road in the Little Sebago development? Did that guy ever build this house? Up behind the lady, the German lady, the German-speaking lady?
Oh, I don't know. I wonder if the house is up there, if he's
Oh.
building.
Yeah, I'm just totally off track.
Yeah, I don't know.
We had an application where a person had a house lot on the road. We'll call it
Right.
Smith Road for the sake of roads. And he owned a piece of property directly behind him. He wanted to build he wanted to apply for variance to reduce the setback for a driveway
To go
from
up this hill.
zero, like something down to 1 foot.
Yeah,
And there were some people that spoke out against it, so we postponed, suspended the hearing, went to the property for a site walk, examined everything. We listened to the neighbors' complaints and concerns, and we listened to the applicant's concerns, what he was trying to do, and we came back and continued our meeting following the site walk. And again, right in the middle of everything, the code enforcement officer comes up and tells us, well, he doesn't need a variance because of the additional dwelling statute. Well, we just
we just went through all
because
this.
he had a buildable lot.
He didn't
and
have
this-
to have a driveway.
He didn't
there.
have to have a well, he had to have a driveway.
Well, he had to have a driveway, but he
But
didn't need a permit
He
to
didn't
do
need a
it.
he didn't need an appeal. So I'm saying, this is something that should have been more closely examined by the code enforcement officer before it ever came to us.
Yeah.
And it would have saved a lot of heartache. What we were, though, able to do is in our finding, we noted the new statute, which made his piece of property a buildable lot, which meant he could have the driveway without the setback requirements. But we were also able to write into our decision what the planning board might call standing condition 1, we stipulated that he must work with the state for the best water management control of storm water that would come down the driveway onto the road, and then down the road and, you know, by the neighbors' properties who were concerned about washouts if this happened. And the neighbor immediately to his right, looking at, standing in his house, who was concerned about water runoff. There was a lot of water runoff into the street. And the neighbor was objecting to the property because water was coming down off the hill off his property and flooding her backyard. So we went to look at where the location of the driveway was going to be, and he had it all staked out for us. Good job there. And then we looked at the abutting neighbor to say, well, let's, and Andrew, not Andrew, but,
Derek.
not Derek, yeah, Derek and I and our third member at the time, we were up there traipsing through the woods, you know, getting bushes and brushes out of our face,
I was up there too.
and going down the hill to say, okay, Mrs. So-and-so, where is the water coming into your yard from the hill?
We couldn't find it.
Because there was a berm there, it was all built up. We were moving leaves out of the way, and it only rained 2 days earlier. Where's the water?
Yeah.
Well, another neighbor, just up out of nowhere says, oh, I know why that's wet. And we really weren't supposed to ask, it's not supposed to be testimony at sidewalk. But he volunteered, that's all clay. So that any rainwater wasn't being absorbed into the ground. And come to find out, the guy was a hydrologist.
Yeah.
But that's one thing that we do. If we do a site walk, we're not supposed to elicit or solicit testimony. We're supposed to wait until they come back and then let them make any comments they have at a public hearing.
Yeah, because we got comments from the people across the road from that too, because of the water.
Oh, yeah,
It was a
It was-
loud one.
yes.
Interesting.
But in terms of the testimony and testimony preparation, it would be nice, and a lot of times we do get a site plan, we do get drawings, we get survey reports occasionally. Some people will give us Google Earth images, and we ourselves as a board aren't supposed to go out and search that. We're only
Sure.
supposed to look at the evidence that's
See
presented
what
to
comes
us.
in,
Yeah.
sure.
So it would be nice if when we get the application, that Google Earth images or tax maps, design drawings were included. A lot of times we get that, but some people aren't familiar with the property. And it's not necessarily a situation where we have to schedule a site walk to get, you know, a full concept, because usually the people can explain it. Or, I might say, last year, people wanted something, do something at Crystal Lake. Is that this house? He says, well, how did you know this? Well, I swim by the house every day,
Yeah.
you know, so I knew where the house was.
Sure.
And not like I was doing any investigation, just by my presence, so, yeah, I know where that is. But I guess I really am looking to see, like, when this page, the shoreline zoning or the practical difficulty or the dimensional appeal comes in. I like, and for a long time, the front page was not filled out. People sent us an attachment or a long drawn out attachment. And I want to see that page filled out. I want to see that, those numbers to be accurate. And I'm really hoping that the code enforcement officer will start training maybe Inga or, who's the other guy? He's part-time here, part-time in North Yarmouth.
Oh, I don't know.
George Fralish, to do a better job of reviewing the application itself, so that we don't have to go through an amendment process for that. Anybody have any questions on that?
I have one question. I saw on appeal procedure for the zoning board, and I think this is for all appeals, it says that all parties shall have the right to present their case of defense by oral or documentary evidence.
Yes.
straightforward. To submit rebuttal evidence and to conduct cross-examination as may be required for a full and true disclosure of the facts.
Yes.
Who is cross-examining who?
The process that we should be using is, and like, you know, like, I will sit here and ask, when the person makes their presentation, I may ask them questions, and I'll say, well, does anybody have any questions they'd like to ask? And Derek would say, has said, well, I have a question I'd like to ask. Derek asked the question, or Drew asked the question. Now, what happens is if the audience has a question, they need to be a concerned party, an abutter or a concerned party.
Sure.
I have a question. They're allowed to ask the question through the chair.
Okay.
So it's not like from this person to this person. What's your question? And then
Okay,
we'll
Okay.
direct the applicant to ask.
that seems more orderly.
Yes.
Yes.
That was envisioned.
Well, it certainly prevents the deputy sheriff from having to be here.
Oh, dear.
You know, dear,
Deputy sheriff.
we had a night where we had to call the deputy
I
sheriff.
know.
Yeah.
Mm.
One of my coworkers was here,
Oh, geez.
Jim Katsifikas.
Yeah,
Yeah.
I mean, it
He's
was,
retired.
he did a good job.
Yeah.
He did a good job. And the applicant's lawyer did as good a job as he could.
Sure.
And Jim has been very helpful to me
Jim's great.
in guiding and directing. He doesn't live in town, does he?
No.
No.
Yeah.
And it was an interesting evening.
But that's the process that we should use, and I think I've tried to do that, is that board members, does anybody have any questions?
Mhm.
You know, Andrew, go ahead and ask your question. Does anybody in the audience have anything? And they say, well, I have a question, and then we let them come up to the podium, ask their question, and then we would ask the applicant to, can you please answer that question?
Sure.
You know, and the applicant will come forward and do that. And it kind of keeps it orderly.
Sure.
And that's the other thing, that I kind of want to look at. If we can go to the back page of this package. I've got a thing called preferred order, but it's non-inclusive. I'd like to see if we can't get it set up. We may have to take, more formal action at a regular board meeting, put it on the agenda. But get the application for variance appeal received by the code officer better reviewed. In other words, it comes in, that's the first thing that has to happen for, anything else can happen, they're gonna get an application for an appeal received by the code enforcement. And then the application is forwarded to the members of the ZBA no less than, I wanna make sure we try to get it no less than 10 days in advance and 7 days in advance. Because I'd like to have that extra couple of days to read it, and maybe go through the code book and do a little bit more homework on it. On the hearing date, and this has not been a regular thing, and I bring it up because of my experience with mediations and arbitrations. The applicant has been aggrieved by either the ordinance or decision-making process. I would like the town, even if it's only, 2 minutes or a minute, to actually present the person, this is why the application was denied, even though it may be a review, but this is why the application was denied. Under practical difficulty, or under this code, or this part of the portion of the zoning ordinance, the application was denied because it needs to have this setback, it needs to have this setback. So just to do a general, very brief review of the application, in other words, hey, you didn't do this, I'm aggrieved, I'm filing a grievance. Well, this is what, it's a grievance or an appeal, very similar in nature. I was, what's the word I'm looking for? Not wounded, I was penalized, you did something wrong, and I was injured by your decision. Yes, I was injured by your decision, I want to appeal. So let's hear from the town, just very briefly, why
I think that
the
would be,
person had to submit the application.
That would be very helpful to hear up
Yeah.
front, and then have the applicant come up and explain.
So that was the second thing, is that, you know, the code enforcement officer presents to the board the action ordinance prompting the filing of the application of the variance or appeal. This is why we didn't issue it. And then we would have the motion to open a public hearing. Now, and listen to all the neighbors, listen to everything that anybody else has got to say. And then at that point, actually declare the public hearing is closed. Because we've gathered and garnered all this information, all this testimony, that can be taken into consideration, that we could take into consideration, but close the public hearing. That way we get to carry on with the applicant's presentation, the examination, the testimony, the cross-examination, if you will, and then making the motions that we're required to make. And then after the 5, let's say if we take the practical difficulty one, after we make the 5 determinations of it, 'cause that's the most,
5 or 6, yeah.
5 or 6 determinations, we would make a motion.
The 6 of them.
I move that the land in question cannot yield a reasonable return unless a variance is granted. And we would have to have a second to the motion. And then Brad would say, well, this is why I think this way. So the finding would be based on the criteria that I establish, that I find. And that's, again, something that I've asked Inga to start writing into the final decisions. That this, and the finding is that the CBA found that the board could not, or establish that the land couldn't do this or that. And then we would move to the second motion, or the second item that we have to consider, the 3rd, 4th, 5th, and 6th, and so on down the road. And then, after that, as long as, even if one of the criteria was lost, I guess, or one of the criteria was sustained, is that what I'm looking for?
Like, one of them's not satisfied? Or
If one of them is not satisfied, if a criteria is not satisfied, no matter what, the main motion can't pass because of that. But, so we do the 4, 5, or 6 criteria. We either sustain them or find that they can't be met. And then the main motion is that, and we typically read it right off the, docket, off the agenda, to read the main motion, and then on the main motion, again, open it to public comment. Listen to the public comment, and then close the public comment for a second time, and then vote on the motion. That seems to be, the most orderly way to do it, and then we kind of more fall in line with Robert's Rules of Order, and we very loosely use those now. But
Yeah, because this is different than what we have been doing. In that, first off, we don't hear from how come it was the reason for the appeal in the first
Exactly.
place. And then we have the applicant come up and speak, and then we take public comments from the neighbors, and then we go through the 5 criteria. So it's changing the order of business.
Well, I think if we are gonna have an open, public hearing, that we need to do that at the beginning.
Yeah, it makes sense.
And then restrict any other additional public comment to the main motion itself. So the public hearing's been held, similar to what the town council does. They'll have, their public hearing on whatever it might be. Then they close the public hearing, then they go to a motion, or to have discussion, motion, whatever, back and forth, and then they vote or make the motion, then they sometimes will open it to public hearing and public comment again, and go, but again, this is something I need to be better at, is controlling the content of the public comment to be relevant to the situation at hand.
Yeah.
Not necessarily, well, I think, you should give it because Andrew's a great guy and he represented me in a legal case once, and I mean, it's nice,
Yep, but it's not
but it's,
pertinent.
and, being small towns, people almost expect a little bit more leniency in a smaller town. And I could probably give that leniency, but at the same time, thank you very much, sir.
Yeah. One thing I have seen with some other zoning boards is that, yeah, people say a great deal of not relevant stuff. But, I mean, it's hard to shut them down for one, because it feels rude. And then secondly, it can be good for them just to get it out. Because if you were to shut them down too early on, they might, you know, go home thinking, oh, well, I don't feel like they really heard me out, and maybe I want to, you know, raise an issue and make an issue of this. So a lot of people find it as sort of like a safety valve to not, am I too quiet?
I don't know if there's a mic, actually.
I don't think any of us plugged them in.
I did.
I can hear everyone else talking about it.
Oh, Andrew was so soft-spoken.
Yes, I was mumbling, I'm sorry.
No worries.
All right.
Well, a little closer.
Yeah, I was just saying, you know, letting people say their piece can be good, just to make sure everyone feels heard. But, I mean, there's obviously a line somewhere.
Well, I think if we give them the public hearing opportunity at the beginning,
Yeah.
and then the opportunity to iterate what they might have said at the public hearing after the main motion, that all will be well. And then to, vote on the main motion.
Sure. The only other procedural thing I was wondering about is I don't think I've seen a like one of the final decisions, and I do know that you were saying like we need to have all of our findings of fact in there. I think that like that is a really important one because it'll like if they appealed it to Superior Court, the Superior Court, if there wasn't findings of fact, they would say, well, we don't know what they were thinking. We just have to send this back, and you see it all the time. So like, in order to not receive it back.
Well, we have two options. We actually have more than two. We could develop, and some towns do this, they have a form that's filled out by hand at the time of the meeting, which does the findings, signed, and that's the final form. We have the option of a clerk, in other words, Inga, or who's ever taken the notes and the messages, to transcribe the motion, the results of the motions, and the reasoning or the criteria that we mentioned in the motion. Say, this is our finding, I move that this and this, and I say that because, the trees are already there, it's not gonna interfere with the existing road or whatever it might be. And, then we vote on it. And then Inga has typically written a finding that included the motion itself and then the results of the motion. But I've asked her to put in a comment about how we came to that decision. To be more specific than just the motion that, or, Georgia might have thought, whatever Georgia thought about, oh yeah, the trees are still along the road and it's not impacting the appearance of the neighborhood. Why did we think it met the criteria? And what she does then is she calls me like 4 days later. I come in and I review what she's written. And the board has allowed that to happen. Probably what we should do to better satisfy the written requirement is to have a motion at each minute, at the end of the finding, to authorize the clerk to write the findings to be reviewed by the chairperson or co-chair, whoever it might be, to review and sign on behalf of the board. Our next option is to have the findings drafted up and then have another board meeting, within 7 or 10 days to approve that, and then.
Sure.
So it's really a matter of, we could leave it historically the way it is, or we could in fact get us together like Jim did once with the place down the road. He drafted the findings, and we came back and read the 3 or 4 pages of findings.
Yes.
And voted to accept it. And in the findings, we did make one change.
Yeah.
you know, which is okay, and it was just a very minor thing, but,
Was it like a controversial hearing? It feels like maybe that approach would be more appropriate if there was like,
if it, I
Yeah.
think, because of the nature, because we had lawyers involved,
Oh,
attorneys,
that one.
it got controversial.
well, it didn't have to be, but it was.
Yeah.
We chose to have the decision written, the findings written by the lawyer
Mhm.
representing the town. And then we met I think a week later, or you said
Mhm.
2 weeks later, we had a special meeting of the zoning board.
Mhm.
We reviewed the findings, the appellant's attorney reviewed the findings, suggested some minor changes, and we all looked at, we can make these changes, we amended the findings to change some terminology from property line to fence line, or
Yeah, okay,
to
sure.
be, and did it that way. So, we have historically, I'm not saying it's the best way, if there was legal representation involved, we asked that the town's legal authority, legal representation would write the findings.
Mhm.
And then we would meet, vote on the findings,
Okay.
and it just made sense.
Sure,
It made
yeah,
sense.
that does make sense.
So,
Cool, thank you.
anything, does anybody have anything? I know there's a lot of stuff here, but. Now, did Tammy make arrangements for you to at least briefly review or watch the video from the Maine Municipal Association?
I have a link. I need to watch it. Yeah. I will.
Okay. I think that, Georgia, do you have anything? And do you still have this? This is the one where the guy from Jensen and Baird came 2 years ago?
Oh,
And we
yes.
met up back?
We met up back and
Yeah.
we went around with Ben. We weren't
Yeah, that
supposed
was
to.
Ben McCall that did that.
Yes,
Yeah,
yes.
He did okay.
he did.
Yeah, I wish he'd done, a little bit more thorough. But I think we've got the gist of it.
Yes, I have every piece of paper that you or Inga have given me, or Pam.
I
Since
guess
it
from-
started.
from a chair's point of view, and I'm being the chair, I really do want to work on certain aspects of controlling comments and
Sure.
being a more orderly, in other words, bringing the, if you will, bringing the arbitration mediation type process in. You're the aggrieved party, tell us why you're aggrieved.
Mm.
Or you're the aggrieved party, town agreed, tell us why you took the action you took. Now, party, tell us why that action was wrong.
Mm-hmm.
And again, limiting our action to interpretation or granting the variance because of, the established criteria wasn't met or isn't being met. And,
Because things came to bouncing in and out. It's like we'll be partway through with this, and then Tammy comes and tells us something else happened, and,
Yeah.
well, if they did this, then they could do that. Well, why didn't you tell him that ahead of time?
well, that was like last week. when we
Yeah,
had
it was-
The dimensional,
Why didn't you just say something ahead of time instead of going back and forth? So if she or Inga or someone told us up front, this is why we denied, this is what the appeal, what the permit request was, this is why we can't do it, why I turned it down, and that's why we're here.
I certainly don't expect Inga to do it, but I certainly
No,
expect
but-
either Georgia or George.
Right.
I mean, not Georgia, but Tammy or George
Yeah,
to
I do know who
that.
George is, yes.
George Fralish. Anything
Yeah.
else?
I think that comment you made about having a motion at the end about the
Doing the
the
findings?
findings, I think that's a good idea.
Mhm.
And
Yeah.
unless there's lawyers, let's not come back to
Yeah.
vote on them,
Yeah.
but if,
And there was something else that just popped in my mind, it popped out just as fast.
oh, my brain does that all the time.
Yeah. I'm gonna ask, with your permission, I'm gonna ask Tammy, and I'm sure that Kyle will have to get involved somehow. to make these 5 forms, fillable forms on the computer.
Oh, wouldn't that be
Oh,
something?
yeah.
So the
Yeah.
person can open up the form on the computer, as it is now, it saves as a PDF file. But to make it a fillable form so that
Hmm.
people can do it right on the computer and print it out or submit it via computer so that we have the form and not necessarily the forms that you can see attached, but,
Sure.
We can use spell check.
Yeah.
make it- I'm the one that needs spell check.
No, they need
So,
spell check.
yeah. Oh, they do, yeah. So if there's nothing else, thank you, Andrew, for coming over tonight. Thank you, Georgia, for coming over
You're very
tonight.
welcome.
We will kid Derek a little bit.
Yes.
But, if there's no other business, we are adjourned.
All right.